Okay, well, welcome to the Law 24 online. It's spring and we're dealing with civil litigation and we're shaping the debate. I'm introducing myself, Andrew McLaughlin, and also present is my colleague and co-presenter, David Amos. Good afternoon,
Good
David.
afternoon, Andrew. Afternoon.
Okay, today's question and answer session is due to last about 1 hour, and we'll cover all the submitted questions that we've received on the various topics that David and I have worked upon. A recording of today's session will be available on the website within the next few days, so please keep an eye out for this. This session is actually being sponsored by Watchman Insurance. Who are Watchman Insurance? Well, they're actually a specialised insurance policy only available to solicitors. It provides insurance for unoccupied properties and has been revolutionary in changing the way probate solicitors protect their clients' estates by reducing initial pressure on your funds whilst you're still trying to access the estate and sell the property. Watchman achieves this as solicitors do not have to pay a full upfront premium. Cover is secured by simply paying a small deposit and continues with a daily premium charge that is delivered until the property is sold or transferred for up to a year. No finance agreements and no cancellation charges are applicable. It's also available for homes where clients are in care or with reduced legal capacity. Getting you started and arranging cover is easy. If you would like to learn more about Watchman, you can contact their helpful team, and the telephone number is 01935 389 812. So that's 01935 389 812, or using their email, which is watchman, which is all one word, at practiceenterprise, all one word, .com. So that's watchman at practiceenterprise.com. So without further ado, let's start with some introductions. First of all, my name's Andrew McLaughlin. I'm a solicitor. I've got higher rights of audience, both in civil and criminal proceedings, and now sit as a recorder in the Crown and County Courts. And I've been recently reappointed as a court examiner by the Lord Chancellor, which involves taking evidence for use in foreign proceedings or taking evidence for use in English and Welsh proceedings where parties and witnesses are too infirm to attend court. My wide-ranging experience in practice, coupled with ongoing training with the Judicial College, gives hopefully a unique insight into judicial thinking and therefore what you should be doing in your practices from day to day. Main areas of specialisation include civil and commercial litigation, as well as all types of personal injury, from road traffic through to clinical negligence. The topics that I've covered this spring for 2024 are procedure in practice and also developments in Part 36 in the last 12 months or so. So that's who I am. I'd now pass you over to my colleague, David Amos. Thank you, David.
Thank you, Andrew. Thank you. Yes, my name's David Amos, and I'm an associate professor in the City Law School. I'm co-author of Dispute Resolution in Contract and Tort, which is one of the texts that Oxford University Press use for their SQE programme. I also do some work outside of the jurisdiction, so I co-authored a guide for the Isle of Man Law Society for their new advocates course, and I've been a visiting lecturer for the British Law Centre in Warsaw and also at Hong Kong University. Domestically, I've done work for occupied roles for the SRA, Silex and the Silex Law School. And I'm also do some continuing work. So I'm on the board of Islington People's Rights, Central Applications Board and Patent Examinations Board. For these sessions, what I did was two areas: current developments in ADR and also expert and witness evidence, recent developments in that as well. So that's me. Thank you very much, Andrew.
Okay, thank you very much indeed for that, David. We now turn to the questions that have been submitted in relation to the four topics that David and I have covered, and I'll crack off with one for you, David, which is in relation to ADR. In terms of practical advice, what practical advice should I give to a client about ADR, non-court-based dispute resolution procedures in 2024, given the changes that you've highlighted in your talk?
Yes, well, this is an interesting area because although you've always had to, this is something you've always had to consider with your client, given what the protocols say and the directions questionnaire. And of course, since Halsey, the risks of any costs being levied against you, there has been quite a big change with Churchill and the ruling in that case, which I think probably in some ways has given the clients less choice. Previously, they could say, well, you could have a discussion with them about whether or not they should accept an offer of ADR or should propose ADR themselves. That decision might now be taken out of their hands because, of course, in Churchill, the court has affirmed its power to order a party to participate in ADR, subject to certain caveats. It doesn't impair the right to a fair trial, and it's a proportionate means of achieving the legitimate aim of settling the dispute. So I think one of the things you're going to have to say to your client right at the very beginning is there is a possibility that the court will take you down that route. I think the difficulty for lawyers is that, or the advice that you give your clients in that case, is that the court left certain things hanging in terms of their decision. And in particular, it didn't make it clear and declined to make it clear when it would make such an order. So I think in some ways, Halsey was, I think, quite clear. It gave you a list of criteria, a list of things that you could discuss with your client. In Churchill, the court has actually rolled back from that and said, essentially, we're not going to give you a checklist, and it will be judged very much on a case-by-case basis. Thinking forward, the other thing that's been left a bit unclear is whether the requirement for some form of ADR and non-court-based dispute resolution will become mandatory, or whether it will be dealt with on a case-by-case basis. And I was looking at something recently where Kim Wager from the Ministry of Justice was talking about potentially extending the ambit of mandatory ADR. So it would be something you'd have to participate in every case. I'm not sure that that will happen, actually, to be honest. I think it's more likely to be kept on. Andrew, I defer to your opinion on this because you may know more, but I would have thought that it will still be dealt with on a case-by-case basis. But with the proposed changes in the civil procedure rules, recent consultation, I think it's very likely that the court, in the overriding objective and in the directions in the relevant tracks, will essentially be saying, if we think this is suitable for ADR, we're going to put you down that route. The difficulty, as I say, is clarity on when they'd actually take that decision. And that, I think, is something that's got to be resolved. So at the moment, the position, there's some clarity in that you can be taken down that route, less clarity in when you would be taken down that route. And that does make it a little bit more difficult, I think, for practitioners in giving precise advice to their clients. Although, of course, one way you can head this off, or two ways you can head this off. Firstly, and it leads into your subject, is make a Part 36 offer if you're confident about the case. Or secondly, and it also is something that I addressed in the presentation, if the other side are merely proposing ADR as a delaying tactic, and you've got, I think, strong arguments to say that it is a delaying tactic, you can at least try to put them to their mettle and to show their bona fides and whether this is a genuine offer that they're making. But as I say, the decision might be taken out of your hands now. the court orders it.
Yeah.
So
Okay. No, I mean, just to chip in there, I think that in a busy list for a judge, a district judge, a deputy district judge, I suspect there will be some cases which are crying out and screaming for ADR, and those are the sort of cases where the judge will grasp the nettle and sort of say, right, well, this is one, example, I suppose. Boundary disputes, a great source of income for lawyers, but often with futile outcomes for the actual clients. Another question, I mean, and please tell me if you're not sure. Should we be calling it ADR now, or should we be calling it NDR? I just
sorry.
wondered. I just wondered. I don't know. I'm not trying to be.
Okay. Well, I think two things. Just one thing to follow on actually from what you said, and then I will answer your question. I'm in the middle of an election, so I'm being like a politician, not answering.
Yeah.
But, I think in terms of what you were saying about sitting days, judges, I think what's underlying this from a policy point of view is to take pressure away from judges by pushing more things more down. The second thing is absolutely, I think you're right. I'm just being old-fashioned in calling it ADR because in Churchill, they were very clear that it's about all forms of dispute resolution. So it doesn't have to be things that are on a statutory basis. And they specifically used, I think, the expression non-court-based dispute resolution because the procedure that they were talking about in Churchill was a corporate complaints procedure from the authority, which really it had nothing to do. It's not a classic form of ADR in the way that you and I would understand it.
No.
So I think probably you're right. It'll take me a while to get used to it, as it takes me a while to call judges judge rather than sir or madam.
Yeah, no, I mean it's really just a tag, isn't it? Really, a name, and I think my take on it was it's negotiated dispute resolution gives it a bit more mainstream rather than it being, as it were, alternative dispute resolution. It's some sort of like a punk band or whatever that may not be selling lots of streaming material. But I think it's probably overdue, frankly, the pushing people down that route. And I think very cannily you talk about people who pay lip service to alternative, and it just whacks up the cost, delays the case, so that they can't be condemned in costs, which is slightly internally inconsistent of an approach.
Yeah, well, you are always going to get people who are trying to game the system a bit, really, aren't you? Unfortunately. So yeah.
Okay, well, thank you for that. Thanks.
No, that's fine. Can we move on to something from Part 36 then, Andrew? If that's okay.
Yeah, if you wish. Yeah,
sure.
There's a question there. Yeah.
Yeah. Sure. So, how does the court approach a Part 36 offer which deals solely with liability, as opposed to an offer under Part 36 that makes an offer to compromise the case in monetary terms? So, is the regime different between the two?
Okay. There is. It's not a different regime as such, but I think what the question is getting at is there's a case in that I talk about called Mundy versus TUI, the travel company, and not trying to be disrespectful at all to the High Court judge who decided that case. Probably gets it right, but for the wrong reasons, which sounds controversial, and I'm not wishing to be so. And basically, what Monday versus TUI is an holiday sickness claim, which many of our listeners won't be dealing with or have much experience of, but the principles apply. But basically, Monday gets ill in Turkey with gastroenteritis, and their claimants' lawyers make a Part 36 offer 90-10 on liability. So liability alone. And obviously, as you can imagine, a holiday sickness claim, you either win or you lose. You know,
Yeah,
it's a bit difficult to sort of say, well, there's contributory negligence because you decided to carry on eating that undercooked chicken at 10 p.m. at night. I mean, it wouldn't really, travel, so to speak, no pun intended, at trial. It wouldn't work through. So why is it done? Because obviously to attract benefits under Part 36.17, the four benefits that accrue by making a Part 36 offer that's successful. And obviously you hope the defendant will lose, they'll lose, it'll be 100% liability for you as the claimant, and therefore 10% on the award, 10% from the end of the relevant period, indemnity costs, and 10% on the indemnity cost flow. So that's what the claimant did. The claimant thought the claim was worth about 20 grand.
right.
But what the defendants did was they made a Part 36 offer on the value of the claim. So they offered the claimant £4,000 in full and final settlement of the case. So when we get to trial, there are two competing offers. We've got a 90/10 offer on liability from the claimant and a £4,000 offer from the defendant. And this is why, presumably, why the case was reported, because both offers bit. The claimant won 100%.
Yeah.
So the Part 36 offer for the claimant, but only recovered £3,700 in damages. So the High Court looked at this and said, basically, I mean, you've talked in an early answer about gaming the system. The High Court judge took the 90/10 offer as really not being of any viable value to the claim, which I think, and I don't want to be controversial, is probably wrong, because there are plenty of earlier cases where, back in 2016, there was a case about the Epsom Racecourse grandstand roof put in by a construction company. The offer was 95/5 on liability. Well, the jockey club who own Epsom Racecourse are highly unlikely to be found 5% to blame when a construction company have put a roof on the grandstand. I mean, it's down to the construction company. That bit, because they won 100%. However, this High Court judge, sort of 7 years later, decides that that isn't a genuine Part 36 offer, because she said that it didn't really cut into the case. It wasn't resolving a distinct issue. Again, I think that's wrong. Liability clearly is an issue in holiday sickness claims, because you have to establish that there was something untoward with the food, that it hadn't been properly prepared or cooked, etc., under the travel package regulations. But what the High Court judge then said, well, let's look at what the defendants offered. £4,000, you've only recovered 3,700. I'm going to say that defendant's offer takes precedence over the 90/10. So I'm only going to award costs on the basis of the defendant's Part 36 offer. So the defendant got costs and interest on the cost 21 days from the end of that relevant period, being the date that the offer was made on their offer. Now, for practitioners, what I would say is this, and I still think it is a perfectly viable step to take to make an offer on liability. Don't be dissuaded by Monday. What the High Court judge was actually trying to get at was an attack on a general view. So it's a generalized view that claimants are only making these offers to attract big benefits in terms of indemnity costs, interest on awards, and the like. Now, personally, and from the rules, there's nothing improper in doing that, because you make it. If a defendant says, yes, I'll accept your 90/10 offer, the claimant's immediately giving up 10% of the value of the claim. So they're conceding something. But as I say, I think the better way to have approached this is for the judge to have said, having looked at the two offers, I think it's unjust, which is in the rules, it's
Yeah.
unjust
Yeah,
to
that's
allow the claimant's offer to stand. So I'm then going to take preference because it's not unjust because the defendant was trying to settle the whole thing. And I
yeah,
could understand that point
yeah.
of an argument, that strand of argument. And in fact, that's what the High Court said in the alternative, right at the end of the judgment, saying, if I'm not quoting it verbatim, but if I'm wrong about what I've just said, which I think probably was respectfully, then it's unjust, and I think that's the way that practitioners should look at it, because I've perhaps aware that defendants may be making lots of traction using this case, not just in areas of travel sickness, but in other areas, in general
Well,
commercial and civil litigation.
yeah, well, that was a question I was going to sort of come back to you on, really, to be honest, because I get what you're saying earlier about travel sickness cases. It's either you get everything, you will get nothing. But in
Sure.
a lot of, even in personal injury cases, there will be cases where it's actually quite sensible to have a split on liability.
Yeah,
So,
sure.
yeah. So, I mean, do you think the fact that it was a travel sickness case might have influenced the way the judge looked at it, or?
I think that was the subtext in it.
Right, right.
There was a perception, be it incorrect or correct, that this was being done to game the system so that they would get huge costs. Now, fixed recoverable costs now apply to travel sickness claims
Right, yeah,
from a
yeah.
few years ago. So they didn't used to, but they were then included because it was felt, for whatever reason, right or wrong, that costs were disproportionate. And there was a suspicion, and that's all it can be, that people were buying in these sorts of claims because they weren't subject to fixed recoverable costs. And so, I mean, I've seen in cases I've tried where you're looking at teens of thousands of pounds in costs for 4 or 5 thousand quid
Mm.
claim, and therefore they said no. Because obviously if you get indemnity costs, you're no longer subject to the fixed recoverable cost regime. But again, just to supplement that, and I know we've got to move on a little, to help practitioners, there's a case called Webb versus Liverpool Women's Hospitals NHS Trust. That was a clinical negligence claim about a profoundly injured child,
Mm.
and an allegation of clinical negligence with regard to the delivery. The claimant's offer in that case was 80-20 on liability. Again, if we think about that, was the child in uterus 20% contributing towards those
Yes.
towards the liability?
Yeah, yeah.
Obviously they weren't. I don't think there was an allegation that the mother was somehow
Right, yeah.
sort of part and parcel of the liability. That bit in that case,
Right.
because they recovered 100% on liability. And of course, it had a knock-on effect for, the multi-million-pound claim that then flowed. That was a split trial, it has to be said. So
Yeah,
it was a discrete issue. But again, the Epsom case with 95.5 shows that you should carry on making these offers and don't just be, as it were, swayed
I agree.
by Monday.
Yeah.
So, well, thank you for that. If I may, I've got another question here that's been sent in to us. This now is in relation to expert and witness evidence.
Right.
How might we use Part 35 questions to challenge the other party's expert's report, which is quite an interesting concept.
Yeah, again, an interesting one, which I'll start. I mean, the starting point is obviously the rules. Okay. And essentially with Part 35 questions, of course, you're getting one shot only, because you have to ask the questions within 28 days of service of the report. You've got a limited amount of time and a limited opportunity, and also the question should be only for clarification. But it's that last point that I want to pick up on, because really what this is related to, I think, is what happened in Chewy and Griffiths, going back to our travel claims in Turkey.
Yeah.
So, I mean, obviously the basic principle, and it's one that's well established, but I think it probably was worth reaffirming from Chewy and Griffiths, was if you're going to challenge somebody's evidence, any witness, but particularly an expert, you should give them the chance to respond to the challenge that you're going to make. And so a lot of the in the case itself, they talked about cross-examining and calling the witness and cross-examining them on the points that you're going to raise, which they didn't do, of course, in Chewy. But that may not be proportionate in every case. And there are other ways in which you can challenge expert evidence, which leads me to the use of questions and how you use questions to challenge an expert's evidence. Because that is actually something right at the end of the judgment, which they did address in Chewy. And I won't actually, I might actually give you an example of something from another case.
Yes, please do. Yeah, I'm sure.
Yeah, but in Chewy, what they did say is that you can use focus questions. Now, what do they mean by focus questions? It means that if you have a particular challenge or a particular criticism that you want to make of that expert's report, you either cross-examine them on it, or prior to the trial, and this is probably the best option anyway, because depending on how the court views the use of oral expert evidence, is to ask questions, expert questions, which specifically deal with the challenge or criticism that you're going to make of the report. So what you're doing is you're linking the questions to what your final submissions would be, really. And what that does do is it gives the expert a chance to explain their position. So you've dealt with the point about fairness, which was what underpinned Chewy, but you've also made it clear what your arguments are going to be. And if you get the right answer, or if the answer is sort of equivocal, you can at least then use that in your submissions when you come to trial. So it's really going back to the point that they made in Chewy about, I think, transparency and being open, but also giving an expert or a witness the chance to respond to any criticisms that you might make of their report. Now, the interesting thing in Chewy is they had actually asked quite a lot of questions of the expert.
Yeah, they had, yeah.
And I would go through them if we had more time, but there's just too many of them.
Yeah.
But if you could, and they are set out in the judgment, and if you got the time, read them, because the questions actually were reasonable questions about the assumptions that underlay the report, largely, but they were quite general. And from that, it wouldn't be straightforward. You'd have to join the dots a lot to be able to have it clarity about what it was that they were going to do to challenge the expert evidence. Just to get this, actually, to be honest, to illustrate that point, there was another case called Much and Allen, which is from a few years ago, which was about the sort of questions that you might ask for clarification. I'll just read the question from that, which I think is much more the sort of question that you might ask, which gives a much clearer view of the sort of case that you might be putting. And the question was, we should be grateful if, and actually to give you a bit of background to the case, Much and Allen was the case involving a passenger who had, in a road traffic accident, hadn't been wearing a seatbelt. And as a result, they were propelled out of the car. Okay.
Yes.
And so the big question is, what's the impact of not wearing the seatbelt? Okay. So the question was, we should be grateful if you could confirm whether the severity of Mr. Much's orthopedic injuries would have been reduced materially, if not prevented altogether, had he been wearing a seatbelt. The answer to the question is positive. We should be grateful if you could indicate which injuries would have been avoided altogether by the use of the seatbelt, which would still have been sustained, but would have been less severe. Now, actually, the claimant did object to the questions, not immediately, strangely enough, but they did object to the questions. But the court said, well, what's the point of these questions? They're there to help us judge the case. Now, if you look at the question that they asked there, it's very clear what their line of argument is going to be. That's not about a challenge necessarily to the expert's evidence, but you get the point. Nail your colours to the mast and be clear about the arguments that you're going to make in the questions that you ask. So that would be my advice to you. And it does mean, of course, because I said earlier, 28 days, you haven't got a lot of time, but you are going to have to give some thought to how you actually phrase the questions and what they're actually leading to in the end. Really.
Yeah, I'm just flowing on from that. If I can ask this, clearly the rule in terms of questions to experts envisages clarification. Does the Court of Appeal square the circle with the difference between clarification and cross-examination? Because I know there was an earlier High Court case where I think a deputy High Court judge just sort of said, no, you can't ask any of these questions. It's all cross-examination.
Yeah, no, it's an interesting one, because in TUI, no, they didn't. And in TUI, they just said, look, ask focused questions without any further guidance.
Right.
In Much and Allen, they did actually address that point, because what they said was, and this was part of a general discussion about whether the questions were permissible, etc. In what they said was, these are questions that could have been asked on cross-examination anyway. So we're going to allow them because you would have got the evidence out in any event. So in TUI, no, but in Much and Allen, they took a more, I think, quite a pragmatic view, which is the evidence is going to come out anyway. It just came out earlier, really. And that what they said was, the whole point was to allow the court to have all the relevant information in front of it when making the decision. And that was their reasoning, I think, behind allowing those questions. Well,
sure. I mean, therefore, I mean, I know we've other topics to cover, but is I mean, say if I've got it wrong, is it fair to say, therefore, that, for instance, if you've got a modest value claim that is in the fast track or the intermediate track, where it's unlikely you're going to get permission to rely on oral evidence at trial, that actually you've got to go for it under questions under Part 35, because it's the only way you're going to diminish the other side's case?
I think that's probably right. That wasn't that you're putting it at a higher level, I think, than the Court of Appeal did. What the Court of Appeal said, what we don't want to do is to encourage a load of people to get their own expert evidence in cases where it would be disproportionate to do so. But I think the logical conclusion of it is what you say, which is, if you want to challenge the expert evidence and you're not going to get the chance to cross-examine them, Part 35 questions is your chance to do so.
Because it's the only way.
It is. What else are you going to do? You know. Although, I mean, to be fair, there are lines of cases where the court has rejected expert evidence, even single joint expert evidence, because of the other evidence that's come out. But that's really dependent on what happens at trial, and that is a bit of a risk, really. I think probably try and anticipate it at an earlier stage is what I would do.
Okay, thank you for that, David. Okay.
Thank you. Now, sorry, I've just can I move on to a question for you, if that's okay?
Yeah, sure, absolutely,
And we talked earlier, actually, and this does pick up on something we discussed earlier, which is about fixed recoverable costs, which I think is going to be quite a theme over the next couple of years, really, to be honest, with the changes. So just if you could bring us up to date, really, what changes have been brought into fixed recoverable costs in April 2024?
Okay, yeah, thank you. The answer is there have been quite a few changes, most of which were anticipated when the fixed recoverable cost regime came in. In other words, the Civil Procedure Rules Committee spent a heck of a lot of time crafting a wholesale change. I mean, revolutionary almost change, or certainly a very significant impact. Fixed recoverable costs have sort of been in a few, as we know, road traffic, personal injury, ELPL type claims. crept into travel sickness, and now have been expanded across the board. Therefore, piggybacking onto the changes from October 23, first of mostly really good news, in fact, for practitioners. One, there was a 3.2% increase in the fees.
Right.
So no, which is not exactly inflation beating, but at least is an increase. And it was accepted that the figures that had been put in October really were old, somewhat aged, and obviously inflation had been quite rampant anyway. In the intervening period for a period of time. Secondly, there was an introduction of late settlement of cases. So there was an abrogation of council's fees. I say council's fees, advocates' fees. I mean, remember, every qualified solicitor at least has rights of audience in the county court. And I'm always one, as a higher rights person myself, trying to encourage solicitors to get higher rights. But you've got rights of audience in the county court, so advocacy fees in terms of late settlement were changed so that counsel would get, or advocates would get, something if a case settled, say, 2 days before a fast track trial. Otherwise, it was nothing. So that was I suspect the lobby from the Bar Council to get that in, although it obviously included advocates. Another change was the fact that parties could agree to disapply the fixed recoverable cost regime. So by agreement, the claimants and defendants to a case can say, actually, we agree mutually not to be bound by the fixed recoverable cost regime.
Can I just pick up on that, Andrew? Because that to me is quite a revolutionary thought, really, to be honest, because it does mean that, well, I mean, is that for all tracks and all cases?
Yeah. But everybody has to agree.
Right. Okay.
So, I mean, it's perhaps, if a defendant thinks they're going to lose, it's going to be hard pushed to think of a defendant sort of competently advised who'd say, oh, do you know what, we'll disapply the fixed recoverable costs regime and open up, expose our client.
Punishment.
Expose our client to the to standard costs, as it were, which can happen. And I think the other little wrinkle that probably still needs to be completely ironed out is if you've got a case whereby contractually a party in the agreement agrees to pay the standard costs in a clause, does that get nullified by the imposition of fixed recoverable costs? And I think the answer is probably no, because it's a contractual entitlement and it would probably need primary legislation to knock out that clause. I mean, it's subject to it being, not knocked out by any consumer regulations or consumer rights. But clearly, if two parties were commercial entities and there was a contract clause that said if the matter goes to a dispute, the parties agree that the tenant, by way of example, will be responsible for the reasonable legal costs. There is an overarching entitlement by the court, even in those circumstances, to assess the costs. So, even if it said, somebody says, oh, well, we've been dealing with this case for 3 weeks, our claim for costs under the contract is therefore £1 million. That is subject to an assessment by the court as to what's reasonable. But those are really the main changes. The final changes is in relation to restoration of companies and recovering coroner's inquest costs. So the attendance at a coroner's inquest for a fatal accident claim or restoration of a company noise-induced hearing loss, by way of example, where a company's gone to the wall, but someone was employed at the time. Those I think are in at 1280 plus VAT, something that are recoverable now.
Well, that makes sense to me, because those are steps that you've got to take. But that does lead me to a question, actually, Andrew, which is I can see. I mean, it's a certain amount of crystal ball gazing, but can you see further amendments to the fixed recoverable cost regime coming in?
Yeah, there are. That
Yeah,
clinical negligence claims to 25k are probably likely to come in October,
yeah,
and there may be changes to the way costs are going to be assessed um, generally. So that
right.
may come into a fixed recoverable cost regime. That I think is still open for debate. I think there is probably a concern amongst maybe senior members of the judiciary when they see some of these cases, and the actual costs of assessing costs is
Yeah,
creeping up to become more and more disproportionate. The Jackson changes brought in provisional detailed assessments
yeah,
from 75k plus to try and stem satellite litigation costs for assessing costs. I still think that that may come in, but certainly, I mean, David, there is a push um, uh, ongoing to bring more cases within the fixed recoverable cost regime,
mm,
and really, in effect, the impacts on the client. You know, unless some firms actually go out on a limb and say, we will do your case for the fixed recoverable cost, the
yeah,
the actual final impact is always on the client. They're having to pay more and more a difference between what you can recover from the other side and what they're incurring themselves. Now, that, as I said in my little webinar about this, that does mean tactics need to change in civil litigation in the intermediate and fast track type cases. You've got to have your weather eye on that difference. And I think also client care letters need to change, the client care retainer. You can give specific examples now in a fixed recoverable cost regime. If we get to stage X in your case, we will recover X if we win, or we will recover Y if we win, and your likely cost may be twice that. What you know, so at least there's more of an informed decision for a client to
yeah. It's
make.
more of a difficult sell for the client, though, isn't it? Really, in
It
some
is.
senses, but at least they're going to with their eyes open, weren't they? Really?
Sure, and also the other side, the other side of the coin, though, David, is defendants who who think they're going to lose, or they've not got much prospects of winning. Probably better example will say, do you know what? Let's run it.
Yeah, yeah,
We might have a 20% chance of winning, 25% chance of winning, but if we lose, we're only going to lose the fixed recoverable cost in terms of outgoings to the other side. I mean, obviously we've got our own bill to bear in mind, but that would make it cheaper to fight a case where there are less prospects of success for a defendant. And similarly with a claimant, where the prospects for sex might be 40, 50%, you might say, well, do you know what? Let's give it a go, because we've, the amount that, the, the amount that we reach an agreement with our own solicitor, and if we lose it, we're only paying a fixed recoverable cost at the other end
yeah. No, that is
of the
interesting,
case.
isn't it? That is
So
interesting.
people do need to think through I say tactics. They're not really tactics. They're really different thought processes that you need to adopt to give best advice to the client in these cases. And there's very little guidance as to what bandings these cases come into. Bands one,
Yeah,
bands two, and there's big differences between bands 2 and 4 in the intermediate track. And I suspect, and I suspect what will happen if when it does get to the Court of Appeal, the Court of Appeal are just going to say it's all factual, it's all fact sensitivity. We can't give any general guidance about this.
yeah,
So and really the directions questionnaire on these sorts of cases, in terms of getting the band right, that's where you've got to put the big push. That's where all the persuasion's got to go in at that
Yeah,
stage.
that is interesting because the bands are, as you say, pretty broadly drawn. Really, they are pretty broadly drawn, and you probably have more of a feel than I do of where things are going to get placed. But I think that's again going to take a while to settle down. I think, really.
Yeah, it'll just come down to fact sensitivity.
Yeah, yeah.
It's deliberately, and I'm not being critical, it's
Mm,
deliberately broad brush
mm, mm.
so that it's easier for a court to say it's in band two and give
Yeah.
some reasons why. I think my concern is, particularly in the intermediate track, is that it says whether more than one issue. Well,
Mm,
we'll
mm.
get litigation lawyers, in a relatively
Yeah,
straightforward
yes.
case. Well, there's actually, 15 and a half issues in this
Yeah,
case, when
exactly.
actually it's really straightforward.
Yeah,
So I think that probably needs some guidance as to what constitutes um,
yeah, yeah.
an issue. But I mean, as I say, so I think we've probably slightly digressed from those changes. Let me move on again. Someone else has asked this question, and we're going back to ADR. What type of ADR schemes are contemplated in the Churchill and Merthyr Tydfil
But
case?
it goes back actually earlier to the comment that we made and the brief discussion that we had, and I was going to follow it on, but I was conscious that we were at the beginning really, which is this whole idea of it being non-court based dispute resolution, or as you said, negotiated dispute resolution, or
Yeah.
whatever terminology you want to put on it, because um, interestingly, in Churchill, we talked already about the type of scheme, but in the judgment itself, the Churchill tried to argue that there was a distinction between statutory and non-statutory schemes, and the court said no, that's not going to, that argument is going to fly. And so where they've left it is pretty much any scheme which they think will help resolve the dispute is allowable.
Right.
And what the judge should do in each individual case is judge the particular scheme on its merits, and also where we are in the case. Because the ironic thing about Churchill was we had all this discussion about, yes, we can force them down that route, but in the case itself, they declined to do so because things had moved on so far in the case itself. Really,
Yeah.
so it will be a case by case decision as
Mm.
to what sort of dispute resolution procedure should be followed. Um,
Yes.
what doesn't help is the court then declined to take the next step, which is to say these are the criteria by which you might judge those particular forms of dispute resolution. The Bar Council have made a submission, quite a lengthy submission, about the sort of criteria that should be used.
Yes.
Mr. Churchill himself, or through his lawyers, have made various submissions about the scheme that the council who had proposed. And of course, there's the criteria from Halsey. And in the Churchill decision, the court said, well, all of those might be relevant, but we're not going to give a checklist. And
Yeah.
so they were very clear on that. One interesting thing, though, that has emerged since then, because I think Churchill's changed the landscape.
Hmm.
We will get a change in the civil procedure rules, and we will go down the route of court saying, we discussed this earlier, that you will go down some form of dispute resolution procedure. But one of the things I think the MOJ are looking at, and there are some discussions presumably going on, which I'm obviously not party to, with senior judiciary, is more judge-led mediation, more judge-led dispute resolution. Going back to what you said earlier, there may be
Yeah.
cases that you can look at where you say either you're going to go down a process, or you're going to initiate a process yourself.
Yeah.
What that looks like, I'm not entirely clear, although in the remarks that I saw from the MOJ, they talked about, there was an example from a district judge, I think in Northampton, who'd got people lined up so that they could effectively refer litigants to those dispute resolution procedures. So I think what's going to happen, I think the answer is it's a much broader field, and there's going to be a much broader set of dispute resolution procedures. And if they meet the aim of leading towards a just settlement of the case, then the judge is going to allow them, whatever they are. Really, that seems to my interpretation of the way things are going. Really.
Yeah, I mean, just to supplement that, because it's a bit apposite. The present rules prior to the Churchill case, isn't there not? I think, just off the top of my head, is it 3.12M of the civil procedure rules, early neutral evaluation? A court can implement ENE mandatorily, because there's a case management decision. And so that you could envisage it going that way. And secondly, and just really for hopefully the edification of our listeners, Birmingham County Court, literally 90% of the small claims matters issued or defended in Birmingham County Court go to a dispute resolution hearing, judge-led.
Yeah.
So, and I think the only couple of examples, the only two sort of main areas is where liability is disputed on a Road Traffic Act type case, might be a claim for credit hire, and the like. But the vast bulk of them, and we're talking, £50 claims, £100 claims, parking charges, you overstayed your welcome, all go to a small claims dispute resolution hearing where they are defended, and with a view to the judge getting a hold of them, the block listed, and they and no, obviously not many have got solicitors involved, but some have.
But to see that, to me, makes perfect sense, actually, really, because going back to the whole basic point about proportionality, why would you prolong these things when the value of them is relatively small? It's where what the issue, I think, will be when we get into the fast track and intermediate track type claims and how that's dealt with on those type of claims, I think. But, yeah.
I mean, again, just as a general landscape point, in my time as a practitioner, at the beginning of my career, whatever you want to call it, if that's what it is, well, it is, like it or loathe it, you could pick the phone up to an opponent, quickly. That sort of was decimated by departments evolving, larger entities where only people would work on a particular part of a case. They didn't have overall responsibility. So if you wanted to pick the phone up literally and metaphorically, often there wasn't anybody to speak to, because the case would be with someone who didn't have the authority to discuss the case with a view to settling it. And these sort of almost sort of internal hurdles were very difficult to get across, get through. And so, I mean, for my mind, ADR, NDR, non-court dispute resolution includes picking the phone up and talking to someone about it. You don't need a JSM in a a corporate boardroom to resolve some of these things, providing people have got the authority and the competency and the knowledge on the case. You can cut through a lot in that way. And I think, I mean, I'd encourage any practitioner, if you think you want to settle the case, push to speak to someone about it. I mean, because emails can be so clunky.
Yeah, and easily misinterpreted as well, really. So
it can be, and I don't think email negotiations necessarily the most fluid or effective way of actually reaching a compromise as such. But
Okay.
we've probably just got time for one more question.
Okay. Well, then if I
I
can,
believe whichever one you want to, whichever one you want to go for.
well,
If
we can have a
you've
more,
got any,
we can have a longer discussion about fixed recoverable costs if you want, or which I was going to, because there is a slightly different regime on Part 36 with fixed recoverable costs on the fast intermediate track.
yeah,
If you think
um,
you've got time to deal with that, if
I,
not, then we can.
I can. I can. I mean, it is in the notes, and I think somebody's raised this just because it's um does change the Part 36 landscape, and the rationale behind it is to make it much more easy to calculate
Mm,
what additional items you're entitled to. Now, the point is under the intermediate and the fast track where we've got fixed recoverable costs in play, because obviously some cases may not fit in. You can apply for a dispensation, but assuming it's a fixed recoverable cost case in the fast track and the intermediate track, the claimant no longer gets the four benefits under 36.17.4 that they otherwise would have. Um, it's probably not going to be as generous in numbers terms to what the old regime was, but done with a view to be easily being calculated, and of course preventing the need to have further assessment of costs at the end of what could be a modest what would have been a multi-track case.
mm,
Um, so the answer is that first of all, it remains an unlevel playing field. All the defendant gets are costs, um, uh, a cost differential. So to give you an example, the defendant makes a Part 36 offer, let's say, of £17,900. The case goes to trial. The claimant recovers £16,000. Okay,
mm,
that's the outcome.
mm,
Defendant says, "Here, judge, Part 36 offer. We've done better than our own offer." What will happen? First of all, the claimant will recover the costs on the fixed recoverable cost basis up to the end of that relevant period, the 21-day
yeah.
period. I call it the thinking time.
Yeah.
When you receive the offer, you've got, the relevant period is the
Yeah.
time you've got to think about it. So the thinking time, when the thinking time comes to an end, at that stage in the proceedings, the claimant gets those costs. Then the defendant gets the end point fixed recoverable costs at trial. So whatever the fixed recoverable
Essentially,
costs
yeah.
are at trial, um, uh, uh, they get. And
Right.
then what the court does is deduct the claimant's entitlement to costs from the defendant's end figure. So let's say because the defendant has done better at trial, the defendant's costs are, let's say, total £17,000.
Mm,
The claimant is getting £9,000 up to the end of the thinking time when the offer was made. You deduct the 9 from the 17, the defendant therefore gets a net 8 from that
yeah.
Part 36.
That's quite clean, actually, isn't it? Really, to be honest, and it
Mm.
preserves the split costs order that we had before. So you were saying it earlier that the claimant, the incentive for the claimant is slightly less. Have you,
Yeah.
if you've got time, do you think you could explain?
Yeah, briefly. Yeah, I
Yeah.
can. You've just got time to go. I mean, the answer is 35% of the difference. So if we keep that as a bold, blunt answer, 35% of the difference is what the claimant gets. And what is the difference? The difference is you take your end of the relevant period when the claimant's Part 36 offer was made. Where did the music stop on the fixed recoverable costs at that stage? Obviously, the earlier in the proceedings, the lower the figure.
Mm, mm,
Okay. We then look at the end point. What are the claimant's costs at the end of the trial? and you take the first figure, deduct it from the second figure, and you get 35% of that. So let's say a claimant makes an early Part 36 offer, and at that stage in the proceedings, when the thinking time is come to an end, their entitlement on that case would have been £4,000 in costs. Okay. We then jump forward to the end of the trial. By the time the trial's ended, the claimant's cost might be, let's say, 25,000, or let's call it £24,000.
Yeah.
Okay. We deduct the 4 from the 24, we're left with 20. We now get 35% of 20.
Right.
Which is £7,000.
Right. So there's still a reasonable incentive for a claimant
there is,
to make an offer, actually. Yeah.
And the earlier it's made, obviously, the bigger the difference at the end of the trial, and therefore the 35% is bigger. And that's really how that operates. But it's, as you've said, David, it's a cleaner approach to it. I suspect claimants practitioners will be unhappy because they will point they will point out and say, well, just look what we could have got. You know, at £50,000 multi-track claim would have attracted indemnity costs, interest on indemnity costs, 10% on the award, and 10% from the end of the relevant period by way of interest above base on the you know, the daily rate on that particular figure that was awarded. So they're probably it's, you know, swings and roundabouts, but probably less beneficial to claimants, but certainly much easier for a court to calculate.
Yeah, it is. Yeah.
At the end of a 3-day intermediate track trial, because it applies there as well, and therefore you're not having to go. I mean, it's not good news for cost drafts people. The tranche of their work's gone because there's no, of course, budgeting on the intermediate track, and obviously these spin-off matters. But you know, I don't. The rules are, you know, I'm very sanguine about it. The rules are the rules. We might not like them. Some people may love them. The fact is, we're bound by them, and we've just really got to try and help practitioners as much as we can to navigate through these waters and make sure that there's professional propriety there. We're looking after the client's best interests without, cutting ourselves by, sort of dive to the bottom in terms of cost, because the risk is then the quality goes. As an old adage, anybody can work for nothing. In a profession such as this, we don't want that to be happening, because there are horror stories of people sort of deciding they'll have a business approach and not really recruiting or training, perhaps. More to the point, and mistakes occur, and there are some shocking outcomes.
Well, that I think is always a potential consequence of fixed costs, really, isn't it? And it's just as much as anything else is the level of them, because you will manage your case, your firm in a way that you can make money out of it.
Sure. So, and I don't think these, I don't think fixed recoverable costs in with a view to a dive to the bottom.
No, I don't think
in terms of service. I think it's just Jackson wanted fixed recoverable costs in the fast track in 2013.
Yeah.
So it's taken 10 years to actually bring it in. I mean, in fact, if you look at it, and I know we're sort of into extra time, so to speak, but it's always been a bit of an Alice in Wonderland approach, where we had cost budgeting in bigger cases and zero cost budgeting in smaller cases in the fast track, when there wasn't, as it were, all right, PIEL, PL, RTA was subject to FRC in 2013, but the vast bulk of fast track cases weren't, and it's taken that length of time to get them in. In fact, I think Jackson's done 2 reports post 2013 to actually get this in. But I
Yeah.
think that probably brings us
Okay. Yeah. Sorry.
to our
It's an
conclusion. No,
interesting
no,
subject. We could
no, it
carry
is,
on
of
to it.
course. Yeah, no,
Yeah.
no. And
Yeah.
I'm just mindful of. I think we both have to be proportionate, David, in the
Yeah. That's very
in
true.
the in
Yeah.
the
Yeah.
amount of time that
Yeah,
we're
exactly. Yeah.
spending discussing these matters. I mean, just one question I was going to ask you, just to, just as and this is really a summary um, of uh, if there's a takeaway from ADR to give to our listeners, what would you say? Like a big headline to
Big headline.
take it.
Gosh, now that's
Yeah.
an interesting one, actually. Well, I think, and actually, to be honest, what I think is a takeaway, which is broader, but it does involve ADR, is that the landscape is really changing. And actually, if we put together the things that we've discussed, which are fixed costs, ADR, the way you deal with evidence, etc., there's a lot of changes going on. And yes, you might change the way that you conduct your practice, but it will be probably having a sort of handle on the systems of ADR, what's the most effective, is probably going to be of benefit to you, really, I would
Mm-hmm.
say, because I can see that's very much the route that we're going down. And in a system of fixed recoverable costs where you can reach some sort of agreement at a relatively early stage, and if you can't, then you make a Part 36 offer. Then I think that's probably very much it's a tweak to the way that people will run their cases, but I think that's very much the way it's going to go, particularly obviously for lower value cases.
Yeah. Okay. Well, I
And,
think on
and
that great point, it's probably a good opportunity to finish
right, okay.
on. And I suppose one area maybe the rule makers need to look at, if they are encouraging lots of ADR in the fast track, is there going to be an accompanying entitlement to costs as a result of, pushing fast track work into ND or AD, or call it what you will?
Yeah,
Because
yeah,
as I understand it at present, there is no element in the fast track or an ADR option where there is in the intermediate track
no,
in terms
no,
of fixed
yeah,
recoverable
yeah,
costs. So, but and what becomes the costs that are incurred there? Because they're often going to be contractual costs, aren't they, that are incurred with for instance, the appointment of a mediator. I accept it's unlikely you're going to get a mediator in a fast track case, but that maybe that's something the rule makers need to look at if people are being pushed down, because who pays for a JSM in a
yeah.
fast track in a fast track matter? Hence my encouragement: pick up the phone.
Yeah, I think you're
In
right,
it,
and I think it's going it's going to evolve, really, is what I think, and I think there will be more changes coming down the line. I think you're right.
yeah. Okay, well, great to speak to you,
And you,
David. And I think we've brought it to a conclusion. And again, just to remind everybody, obviously accompanying this discussion are the four topics that David and I have covered. They come with detailed notes as well. Thank you, one and all, for listening into this. And could I finally thank David
thank you, Andrew.
for his contributions, wise as ever. Thank you very much. Good
Thank you.
afternoon.